Senator from Rhode Island.
Mr. President, I'd like to say a few words about the battle here between the jury system and a system in which regular Americans are forced into arbitration, which has a terrible record. I can remember years ago when I was Attorney General, the Attorney General shut down one of the arbitration systems because it was so corrupted and was throwing decisions to big corporate interests. And you can't really understand that unless you understand the importance of the role of the jury in our country. For centuries, the jury has served as a last sanctuary within our constitutional structure for people who seek justice and fair treatment under the law. It was designed for a specific purpose. When big interests control our executive officials, as the Founding Fathers knew they could, when lobbyists have the legislatures tied in knots, as our Founding Fathers knew they could, and when media outlets steer public opinion against individuals, as our Founding Fathers saw that they could, the hard, square corners of the jury box stand firm against that tide of influence and money. There is a lot of history here. It was the earliest American settlers that brought the jury to our country as precious cargo from England. The Virginia colony established the jury in 1624, roughly a year before the Dutch even settled the island of Manhattan. Early Americans created juries in 1628 in the Massachusetts Bay Colony, in 1677 in the colony of West New Jersey, and in 1682 in Pennsylvania. Indeed, in our Declaration of Independence, our colonists put forward a list of grievances and admonished King George III for, and I quote them in the Declaration of Independence, depriving us in many cases of the benefits of trial by jury. When the original Constitution was silent on the civil jury, Americans sounded the alarm, and the Seventh Amendment was sent to the states in the Bill of Rights. Alexander Hamilton is a famous revolutionary founder. He stated in the Federalist number 83, and I quote, "The friends and adversaries of the plan of the convention, if they agree in nothing else, concur at least in the value they set upon the trial by jury. Or if there is any difference between them, it consists in this: the former regard it as a valuable safeguard to liberty, the latter represent it as the very palladium of free government." Going on to the mid-19th century, when Alexis de Tocqueville wrote his famous Democracy in America, he observed that the jury should be understood in America as a, quote, political institution and, quote, one form of the sovereignty of the people. What did he mean? How does the jury protect the sovereignty of the people? Well, in two ways, as Sir William Blackstone explained. Sir William Blackstone was probably the most cited source in those early days of the founding of our republic and in the early days of the development of our law. Sir William Blackstone explained that trial by jury preserves in the hands of the people that share which they ought to have in the administration of public justice and prevents the encroachments of the more powerful and wealthy citizens. Those are two separate thoughts. First, the civil jury devolves a share of government power which they ought to have directly to the people. But second, and uniquely in a constitution otherwise devoted to protecting the individual against the power of the state, the civil jury is designed to protect the individual against other individuals, more specifically against other more powerful and wealthy individuals. Even former Chief Justice William Rehnquist observed about this era, and I quote him here, "The founders of our nation considered the right of trial by jury in civil cases an important bulwark against tyranny and corruption, a safeguard too precious to be left to the whim of the sovereign." That is at heart what this fight is about. Remember Blackstone's words: the jury prevents the encroachments of the more powerful and wealthy citizens. Well, that means the jury is intended to be a thorn in the side of the powerful and wealthy. It is intended to make the powerful and wealthy stand equal, annoyingly equal to them before the law with everyone else. The jury is intended to be the little branch of government the wealthy and powerful can't get to, can't fix, can't control. That's why jury panels are new every time. If you had a permanent panel of the same jurors over and over, the powerful and wealthy would tend to influence the institution. The jury stands against all that tide of influence. That's what it's there for. That's how it was designed. Who is more powerful and wealthy today than mighty corporations and big special interests? And guess what? Big corporations and special interests hate the jury. The small institution has big enemies. It would astound the Founding Fathers to see how far we have fallen from the popular affection and loyalty for the jury trial in 1776. Juries are indeed about dispute resolution and about making sure that everybody can get a fair shake and that powerful and wealthy interests can't put the fix in. But more than that, the civil jury helps check power. The American system of government is built on the premise that divided government and separated powers, checks and balances, will best protect individual liberty. The civil jury distributes authority of the state directly to citizens, giving them direct power to resolve disputes, sometimes very important disputes. And it gives them this power in a way that makes it very hard for special interests to control. Well, if we look around, today, the influence of wealth and power suffuses the legislative and executive branches. Corporate lobbying and corporate and billionaire election spending are at unprecedented levels. In our political debate, dark money dollars drown out the voices of average citizens in what has been called a tsunami of slime. And all that money is not spent for nothing. Powerful interests love a game that is rigged in their favor. Always have, always will. It's a tale as old as time. Well, rigging the game doesn't go over well in the jury box. Special interests may seek special influence with legislators and regulators all of the time. It is their constant activity, licensed and regulated by lobbying and campaign finance laws. Their every waking moment is devoted to tampering with the legislative and executive branches. But tampering with the jury is a crime, and it's a crime for a reason. In a world where so many feel powerless, juries give regular citizens real authority. In a world of fractious partisanship, juries make citizens work together and decide together. And in a world in which injustices pile up against barricades of well-kept indifference, a jury can blow the status quo to smithereens. This is the vital constitutional role of the civil jury. This is what mandatory arbitration is designed to attack, to remove the access of regular citizens to this institution of our government, which was so important to our founding fathers because it is an institution that the wealthy and powerful cannot control. They can control mandatory arbitration. Over and over again, it has been shown to be subject to corporate favoritism and control. There is a reason that the big and powerful special interests want to get rid of access to the jury and want to force people to mandatory arbitration. They're not doing it for the sake of having their adversaries and opponents get better access to justice. They're doing it to shut off access to the civil jury. They want everybody forced into rigged games. We ought to be fighting to preserve and enhance the civil jury as an element of our uniquely American system of self-government. Our forefathers fought and bled and died to create and preserve this system of government in which the civil jury has a vital role, from Alexander Hamilton to Alexis de Tocqueville to William Blackstone to William Rehnquist. You can go on and on and on through our history with people who have pointed out the vital role of the jury. Squelching it is the task of the wealthy and powerful, mighty corporations that seek to squelch it and force everybody into corporate-friendly mandatory arbitration. We should think on this question in the long view, not who gets the immediate benefit of not having to face trained lawyers, not having to face people in an open forum, not having to be before a free and independent jury. We should think of the message of our founding fathers who put the need for a civil jury right into the Declaration of Independence, who demanded it as part of our Bill of Rights, and who saw it as an essential element of our liberty. With that, I yield. I see my distinguished colleague from Maryland.